Get fresh orders, then after notice, then hearing.
Pattern to mention TRPC number one.
Sir, kindly give your memos. Let us not discuss on merits of the memo. Don't expect that it will be it will be listed. That much I have my instruction, and I'm trying to monitor also. Please. Item 2,
2, 3.
Minutes item 3. Minutes kindly be taken up next week, minutes.
After seeking adjournments on as many as 6 occasions, 7 occasions, the learned counsel for the petitioner still seeks adjournment. Though the matter is listed today at serial number 3, he wants the matter to be adjourned at his wishes the next week. The matter shall be listed on 31st. 31st. Matter shall be listed in the week commencing 13 April 2026, mentioning that already adjourned on 8 occasions and will be disposed of. Mentioning in the cause list that adjourned on 8 occasions and shall be disposed of. What's your name, sir? Mr. Abhinav Sodangi on behalf of SP Sodangi for the petitioner. Item 3.
Item number 2 by law. It will take up next week. That is all. I had taken the judgment of my learned friend by law. That is not covered in my cases. That is regarding.
So if you want to argue on merits, sir, kindly start arguing item 2.
Well,
for adjournment, say avatarana darkar nahi.
Next week, any date.
We presume the judge is not prepared. That's a different thing.
No.
So quickest possible time, we should spend time, judicial time.
Well, next week, any date.
No, sir. Today is the best day.
It will be very simple.
Sir, kahibe. Don't fasten the buck. It's not a tennis ball. So you are the. This is judicial proceeding. This is not a tennis match. Mr. D.N. Misra for the petitioner. Item 2. The 3 days though the matter is though the matter is likely to reach, still adjournment is sought for at the beginning of the day's proceeding. 3 day line add good. Item 2. The learned counsel for the petitioner seeks further adjournment. They seeks adjournment at the beginning of the day's proceeding. As prayed for, the matter shall be listed in the week commencing 13 Chari. Mr. D.N. Misra, opposite party likhiwe Mr. D.N. Lenka, AG.
Item 6. Item 6. 1 week time can be granted to file the proper affidavit. Pursuant to order dated 6.
The matter has been listed since January 2026, starting with 12/1/2026, on 21/2026, on 3/2/2026, on 6/3/2026. Today it is at serial number 6 and likely to be taken up. Stop. At the beginning of the day's proceeding, the learned counsel for the petitioner seeks adjournment. Stop. To grant further opportunity, the matter shall be listed in the week commencing 27 Chari 2026. With appearance of 6 re Miss MS S. Ponda for the petitioner. Yes, next.
Item 7, madam. I prefer to extend to comply with the order 5/26 regarding the securing of money decree, my lord.
The matter was earlier heard on 5/2/2026. In item 7 कहले ना 7. Seven आपर अपन अन्य कहाँ पढ़े है ना एक डाकिए का एक डाकल secretary of communication and legal points, the legal issues were discussed and noted in the order dated 5/2/2026. Because again, it was stuff, adjournment was granted to the petitioner. So again, adjournment was sought for on 6/3/2026 and was granted. Today, at the beginning of the day's proceeding, the matter being at serial number 7, adjournment is sought for on behalf of the petitioner. Stop. To grant further opportunity, list in the week commencing.
Satish sir.
Satish Chari, 2026.
Case 2, 9 to 15. Case 3, case 3, 16 to 22. Case 4, 23 to 30.
Item 30 Miller.
Yes.
I have enjoyed my long time. She died there.
Take a date.
Miller?
এটা কোন ପାଇଁ stay ହେଇକି execution stay ହେଇକି ପଡିଛି
No, stay of operation.
କରିଛନ୍ତି ଡେଟ୍ କରିଦେବେ 30 ଟାକୁ
We commencing 4-5.
On 30. May I tell you, this may be taken up along with RPFM 419 of 2025, arising out of same judgment. This for another.
ଲେଖାଟା ଗୋଟେ ଦିଅନ୍ତୁ
Miller?
ଗୋଟେ ମେମୋଟେ କି ଲେଖା ଗୋଟେ ମେମୋଟେ ଦେଇ ଦିଅନ୍ତୁ
Miller.
so that it can be tagged with the file
I'll file it. I'm just filing it.
ଗୋଟେ କାଗଜଟେ ଦିଅନ୍ତୁ
Archie, item 23. Okay, for 2 weeks time for a reason to.
ଗୋଟେ ଟାଇପ ସାରନ୍ତୁ ଗୋଟେ 5-6ଟା ନେଇଗଲେ ନା ସରୁନି ସନ୍ଧ୍ୟା ସୁଦ୍ଧା ହେଲେ ଆପଣ କିଛି ପରେ 10ଟା ଯାଏଁ ବି ସରିନଥିଲା ଠିକ ଅଛି ଆସନ୍ତୁ yes sir
Item 23. No. Archie, 2 weeks.
adjournment କହିଲେ ମିସ୍ କଲେ ପେଜ ଲାଷ୍ଟ ପେଜ 23 ଟା ଆପଣଙ୍କର you are for the
Petitioner on behalf of Mr. Vijay Kumar Das.
opposite party ପାଇଁ inform କରନ୍ତୁ today we have some I have some difficulty when we truncated so they should not come and wait for me other side କୁ ଜାଣିଛନ୍ତି
नहीं inform कर.
make an effort ସେମିତି କଲେ ଆଉ କେମିତି 23 ଟା ଡେଟ୍ କରନ୍ତୁ
We commencing 4-5.
Interim order to continue.
ଏଇ interim order out of turn କରିହବନି unless the matter is not reached it will not be interim order will not be modified also interim order କଣ ଅଛି ଜାଣିଛନ୍ତି it is there it is stayed till the next date it is not when the court is not interfering or passing any order you should think that I have not mentioned this ହେଲା ଠିକ ଅଛି interim order remains as it is I hope you understand call କରନ୍ତୁ
Item 1.
petitioner none opposite party none the matter was presented before this court on 15/2/2019 notices issued by the coordinate bench notices were issued by the coordinate bench on 26/2/2019 interim orders were passed directing stay of further proceeding in CP number 15 of 2017. Thereafter, on 9/4/2019, Sanjeev Chakraborty is the regular practitioner. That's done. Miss Sinha. Mr. Chakraborty is not there. His name appears. It is your chamber. Item 1. Correct. Shall I mention that? Or I'll not mention that you are present and okay. For like may not be your chamber actually. But on yes. Thereafter, the interim order was extended by the coordinate bench on 9/4/2019. 30/4/2019, comma 30/4/2019. 22/20/20. Stop. On 28/2/2020. It was adjourned at the instance of the learned counsel. You take your seat. Right. 28/2/2020, the matter was adjourned at the instance of the learned counsel for the opposite party. Stop. On 13/3/2020, the matter was adjourned by the petitioner. Stop. Thereafter, after passage of 6 years, it was listed on 7/3/2026 under the heading for referral. 7/3/2026. Stop. The learned counsel for the adjournment was sought for on behalf of the learned counsel for the petitioner. Stop. Today, the non appears for the petitioner, though the matter is at serial number 1 under the heading so on so forth. Stop. The matter shall be listed in the week commencing.
Today.
To grant further opportunity, the matter shall be listed in the week commencing 20/4/2026, indicating that the matter shall be disposed of. Stop. ଏପଟେ add କରନ୍ତୁ. ପରେ opening sentence ଟା କଣ ଲେଖିଛନ୍ତି? ତାପରେ ଲେଖନ୍ତୁ the challenge in the writ application is to the order dated 17/1/2017 passed by the learned judge Family Court Puri in IA number 10 of 2017 arising out of CP number 15 of 2017. The IA was filed under section 36 of the Special Marriage Act, 1954. Seeking rupees 50,000 towards pendentalite expenses and interim maintenance. Stop. The said application was rejected by the learned judge by the impugned order dated 17/1/2019. Stop. ତାପରେ ଲେଖିଥିଲେ ଡେଟ୍ ଗୁଡାକ ଲାଷ୍ଟରେ ଲେଖିବେ ଯୋଉ ଲିଷ୍ଟିଂ ପରେ ଲେଖିବେ ଦ ରେଜିଷ୍ଟ୍ରେସନ ଅଫ obtain instructions from the learned judge family court Puri oblique the court in session of the matter regarding the present status of CP number 15 of 2017 by the next date. ଆପଣ କେତେ ତାରିଖ ଦେଇଛନ୍ତି 27 ତାରିଖ
20.
ଠିକ ଅଛି ହେଇଯିବ ଠିକ ଅଛି yes next
Item 4,
May I please, your lordship?
your name sir
Mohammed Shaikh Ali, my lord.
Muhammad Said Ali
Yes, my lord.
Muhammad Sahid
Shaikh.
sir okay.
SHAYAQUE.
Can you just write in a piece of paper?
Yes, ma'am.
There will be spelling mistake on that. On behalf of Mr.
Alok Kumar Mahapatra, my lord.
Alok Kumar Mahapatra for the petitioner. Yes, please.
My lord, the petitioner challenges the impugn order vide annexure 1, my lord. It's dated 18/6/2022, my lord. Passed by Family Court Jabaripada, my lord. Petitioners, the impugn order was stated that it's not maintainable, my lord, on the ground that the petitioner being a second wife, my lord. Well, in page number 22, my lord.
So, what is your statement? Where is your petition? Have you gone through the brief? Have you prepared?
Yes, my lord.
How do you prepare to argue a revision? This is a revision under which provision?
My lord, it's
Don't feel diffident. Must understand that that you have to develop good habits of learning, and the skills are not available to anyone. So you are privileged to study law and appear before the court. So for arguing a revision, so what you have looked into?
my lord, I have gone through this the judgment stating
Judgment, you are not the High Court.
my lord.
You are appearing for the
And for the
petitioner
my
in
lord.
the trial court.
My lord.
So you must first understand what was the case of the petitioner.
My lord.
What was the written statement? Because what you are arguing, maybe it appears very simple, but otherwise it is very nuanced. It's a nuanced subject.
Well,
And what is your best point, which the learned court, though you argued or though you adduced evidence, you in the sense the petitioner, still the learned court could not, was against it. So that you argue.
yes, ma'am. My lord, my
If
contention.
you read Blaise Pascal, that famous mathematician,
Well,
French mathematician, this was told in a meeting by a very senior judge. So what Blaise Pascal wrote a letter. He wrote that since I do not have time, I have written you a very long letter. So when you spend time in thinking, the letter will be small, and that is very true. That still holds good. That statement is attributed to many occasions to many persons, but Blaise Pascal is the original, maybe in 16th century, when he stated this. So we should spend time, the effective summation will be always less. So he writes, because I didn't have time, I had to write you a very long letter. Because he could not pontificate. What is the point? Have you checked any law on this 125 scope of revision?
my lord, I have my contention with regard is that it must be considered into.
No, contentions are not plucked from the tree. It's not a matter of speech, general discussion. You have to see the pleadings.
My lord, it's
Because why I say this? Now you must be thinking that what happened to the judge? How the judge could know that I have read or not read? Because your petition is conspicuously silent in not having those things. For this court to exercise revisional jurisdiction, I must look at what was your pleadings, what was the written statement. Where is that? And what is your reflection on that? And as you know, I try not to pass any sufficient matters are adjourned months together. I mean, giving sufficient time so that you do the proper thing for the petitioner who is knocking the doors of this court. It's not. It can't be sympathy. It can't be sympathy. It can't be the wishes or today I like somebody, I give her. My mood is good. It's not that. Court, I have to, act upon when you are addressing the court. But there has to be substance there. So where are those? What was your stand before the court? How the other side responded? Court coming to rescue, actually in long term, does not inure to the benefit of the especially a young lawyer because he never grows. And courts have been kind enough towards, as a lawyer, I spent 22 years, they have been very kind enough, never coming to my rescue. Only rescue is that they gave me time. Push to the wall, still they gave me time that if I'll read and submit them. Upon the revision ta submit କରୁଛନ୍ତି, revision ta scope देखिए, you have to see, go through that. So that you concentrate on those points, that what was the best point you argued and the court did not consider it. Achhi apna brief re achhi se written statement of pleadings.
No, my lord, it's not there, but
Then how can you prepare the grounds also?
I was relying upon the fact that the relationship and nature of my
Correct. You are relying upon the fact that. So where from those facts? Your personal knowledge or my personal knowledge?
These were held in the case of Indra Saw versus VK.
No. Case law doesn't bring any facts. If you review this, you are saying I am relying on the fact. So who pleaded those facts, or it has to be the personal knowledge of the lawyer and the judge? How the facts are introduced in a case? Is it by impression? Suppose I read a judgment. I gather some impression. Can it be those are the facts? Because it's a judgment before me. Can I gather by impression? I'll gather the facts. The petitioner challenges the order dated 18/6/2022 passed by the learned judge, Family Court Baripada, in CRP number 79 of 2026. The revision ne to apankar eta delay hi nahi. Revision ta bolte.
My lord, I'll prepare well and.
No. I am not dismissing or. Enough. I have assisted you enough. Sufficient material has been given to you to work on. More difficult. Upon first step as a lawyer is not to come to court and start saying something. First step is that you get the brief, read it, think about it, rethink, and then you address. That is important. And there maybe while reading preparing the brief, whether you have seen the plain and written statement, you have to have that inquisitive mind that whether, because you make a statement which is contrary on the face of it, you have no material. I'm relying on the facts that it is that so and so case law. But you do not know what are the facts. The facts are those which are pleaded. And it's a matter of record. You have to see the evidence. You have to see the pleading. That is how the mathematician Blaise Pascal said that since I do not have time, I wrote you a wrong letter. If you have time, you will make a very effective and brief statement.
My lord, time may be granted if.
No, whatever.
Also.
No, judgment dated authorship IC, rejecting her prayer, seeking monthly maintenance
My lord, I
under
will,
section 125 of CRPC. Why you are apprehensive? You are not trusting the court when the court says that I will not dismiss the case or what? Because we have already spent time for nothing. Because my time is not to guide you or help you. I mean, I can dismiss the case. Still, I am not. But when I am dictating order, then I am interrupted, and again I have to spend time.
pardon.
No, like this. Judgment dated authorship IC, rejecting her prayer for grant of monthly maintenance under section 125 CRPC. Stop. The learned counsel for the petitioner was had at some length. Stop. On being asked whether he has examined the pleadings before the learned trial court, learned judge family court, that is the plaint filed by the petitioner, the written statement filed by the opposite party, and whether he has gone through the evidence laid by the petitioner as PW, the statement of the OPWs and the exhibits marked before the learned judge family court. He seeks and has adjournment list in the week commencing 27/4/2026. Yes, next.
Item 5.
And never feel defeated. At times, actually, I mean, lack of preparation results in the court being very annoyed. Rightly so. The courts do not get annoyed by just listening to anything. So that sends a very wrong signal. Yes.
Item 5.
এটাকে পোস্ট করে দিও 5টা করে পোস্ট প্রেস গ্রাজুয়েশন পিটিশনার নাম 5টা আগে লিস্ট ହେଇଥିଲା କି The matter was listed in the week on 13/1/2026 petitioner name. On 2/2/2026 stop କରିକି ବା କମା ଦେଇକି on 2/2/2026 it was had at some length and the issues were noted in the said order. On 11/3/2026 the learned counsel for the petitioner sought for adjournment, sought for and had adjournment. Stop. Today none appears for the petitioner to grant further opportunity listed in the week commencing 4/5/2026. Yes, next.
Item 8.
Mr. Arijit Misra for the petitioner.
Petitioner is the husband before my lordship, my lord. He is challenging the order impugned that is passed by the Judge Family Court Kendrapada in allowing a petition under section 125 of CRPC filed by the wife.
Yes.
Here, my lord, my case is that, my lord. Here, in this case, the the marriage is not disputed, number one. Number two, the income is not disputed. And only dispute is that, my lord. Pardon, my lord. Here the income is not disputed, but here the marriage is disputed, my lord. Because, my lord, if my lordship will kindly peruse Annexure 1, it is a criminal case filed by the present opposite party against the petitioner under section 493, 420, 323 and 506 of the Indian Penal Code, wherein the present petitioner has been convicted under section 493. So my lord, admittedly, there was no marriage between the parties. So the opposite party does not come under the definition of wife, which has been there in section 125 of CRPC. Because 125 CRPC prescribes maintenance for wives, children. Yes. Order for maintenance of children and parents.
Any case law?
That is, statute is clear, my lord.
No, actually, this has been clearly interpreted.
Yes, statute is very clear.
That to the extent that it is not payable to the persons where marriage is disputed.
My lord. Wife means, my lord, it is, it will be interpreted, my lord, it is legal married wife.
Yes.
And to fortify the same, I rely on the judgment passed by the competent court under Annexure 1. And if my lordship will peruse the impugned judgment at page 43, internal page 3 of the judgment, the consistent case of the present petitioner before the learned family judge is that the opposite party claims that she married to one Vijay Kumar Jena on 28/12/2006, where the present petitioner is Vijay Kumar Malik, my lord. And she has produced a receipt issued by one temple. And that has also been exhibited in the case.
You have the Rajit Joshi's name.
Yes, yes.
Can you look at 37, para 37, assist.
Yes. Object of maintenance proceeding is not to punish a person for his past.
37, you are reading assist.
My lord, I am SC 2021 volume 2 SEC 324.
Para 37.
Para 37. In Chaturabhuja versus Sitabai, this court held that the object of maintenance proceeding is not,
reading that, yes.
The object of maintenance proceeding is not to punish a person for his past neglect, but to prevent vagrancy and destitution of a deserted wife by providing her food, clothing and shelter by a speedy remedy. Here the emphasis on
Can you read further?
section 125 CRPC
yes.
is a measure of social justice, specially enacted to protect women and children, and falls within the constitutional sweep of Article 15(3), reinforced by Article 39 of the Constitution.
No, let us skip to 39. To 39. The
issue whether presumption of marriage arises when parties are in a live-in relationship for a long period of time, which would give rise to a claim under Section 125 CRPC, came up for consideration in Chalmunia versus Birendra Kumar Singh Kushwaha, before the Supreme Court, it was held that where a man and woman have cohabited for a long period of time in absence of legal necessities of a valid marriage, such a woman would be entitled to maintenance. A man should not be allowed to benefit from legal loopholes by enjoying the advantage of a de facto marriage without undertaking the duties and obligations of such marriage. A broad and expansive interpretation must be given to the term wife to include even those cases where a man and woman having been living together as husband and wife for a reasonable long period of time. Strict proof of marriage should not be a precondition for grant of maintenance under section 125 CRPC. The court relied on Malimoth Committee report on reforms of criminal justice system published in 2003, which recommended that evidence regarding a man and woman living together for a reasonable long period should be sufficient to draw the presumption of marriage.
Then 40.
The law presume in favor of marriage and against concubinage when a man and woman cohabit continuously for a number of years. Unlike matrimonial proceeding where strict proof of marriage is essential, in proceeding under section 125 CRPC, such strict standard of proof is not necessary.
I'll take 65.
The party claiming maintenance either as a spouse or as a partner in a civil union, live-in relationship, common marriage, should be required to file a conscience application for interim maintenance with limited pleadings, along with an affidavit of disclosure of asset and liabilities before the court concerned as a mandatory requirement. On the basis of such pleadings filed by both the parties and affidavits of disclosure, the court would be in a position to make an objective assessment of the approximate amount to be awarded towards maintenance at the interim stage.
So that clinches the issue, Mr.
My lord, that clinches
So
the issue.
the plea had to be rejected.
My lord,
The plea had to be rejected by the court.
my lord,
Because that
submit one thing, my lord.
because the problem if you kindly look at the judgment relied upon.
No, Rajneesh versus Neha, my lord.
What you have pleaded before the trial court in the judgment para page 12, which you are saying that helped you, that should help you in not getting against the maintenance order.
My lord,
That trial court, criminal trial.
my lord. Rajneesh versus Neha, my lord.
That you kindly no, not Rajneesh. Rajneesh is I think 16. Can you look at 16?
ଏଇଟାକୁ ଖାଲି ଟିକେ କ୍ଲାରିଫାଇ କରିଦଉଛି ଲାଙ୍ଗୁଏଜ ଯୋଉ କହୁଛନ୍ତି ସେ ଲାଙ୍ଗୁଏଜ ଟା ଖାଲି କହୁଛି ଆଜ୍ଞା ସେ କହିଲେ ଯେ ଫର ଏ କଣ୍ଟିନ୍ୟୁଅସ୍ ପିରିୟଡ ଫର ଏ ଲଙ୍ଗ ପିରିୟଡ.
Kindly look at the judgment you are relying on. Page 16, internal page 5, para 7. The learned counsel for the prosecution.
Annexure 1, my lord.
Page 16 of your brief.
Page 16. Yes.
1-6.
Yes.
Para 7.
The learned counsel for the prosecution has submitted PW1 complainant, prosecutrix, deposed that on 28/12/2006, she got married to Bijoy. Whether it is
No, kindly let us not add that.
Yes.
Not the
married to Bijoy in Sahoo Mandir. After marriage, they were staying in their house. Her father had given gold ornaments to the accused. The accused developed relationship with her in a false address. He had given wrong name of his father. He suppressed his address. Later, she came to know that she married to another lady. He was having children. She had developed relationship with him, a false belief. He played with her and her chastity and deceived her. Her life has been ruined, and she deposed that police seized one marriage certificate of them from Sahoo Mandir. Joint marriage photograph certificate issued by Sarpanch on 9/10/2011 and seizure list exhibited 2 and her signature on seizure list exhibited 2/1. The evidence of victim is well established under section 493 and 420 IPC against the accused person. Analysis of evidence of victim, it is found that the accused is a married person. He cheated the illiterate lady. He played with her poor family. When the accused completed his game with false assurance and believed to be an illiterate village lady. And
So that is the evidence. So then look to take to page 20, the learned counsel for the accused. What was your stand before the court?
the learned counsel for the accused submitted in his argument that on 9/8/2009 the accused did not come to her, and from that time the alleged victim prosecutors knew about his wrong name, father name, address in the marriage certificate. The complainant has also deposed that on 7/3/2011 she came to know that the accused had previously married. Some legal gentries tried to settle the matter, but none of the PWs stated that some gentries tried to settle the matter. The complaint petition has been filed on dated 8/8/2011. The complainant failed to explain about the delay in filing the complaint petition. He argued that the PW1 in para 14 had deposed that on 28/12/2006 the accused was entering his name wrong address in the marriage register. On reply, the accused has stated, "Mote baha heicho mo na mo thikonaku." This revealed the complainant was completely aware of wrongful activities of the accused. She has not chosen to take shelter and law immediately. After 5 years, this complaint petition has filed. Non-explanation for it. The case of the prosecution is to be disbelieved.
Can I kindly take 27? Why it was filed before the trial court? We cannot say because you are not the conducting counsel.
No.
Page 27, internal page 60. Run page 27 of the brief.
Yes.
On perusing totality
Yes,
of
yes.
evidence.
Totality of the evidence, I found the complainant in para 2 has testified that to 28/12/2006 she got married to accused Bijoy in Sala Mandir. Thereafter, they stayed in their house. Her father had
Those are
given.
the findings given by the trial court. That is not.
Yes. Pending.
Then page 30. No, appeal is pending, but you are relying on this decision
Yes, yes.
before the trial court. Then look at page 30. The law is well settled.
Yes. That living together in the same residence, generally either as husband and wife or for a extended period of time, as if the parties were married. Cohabitation implies that parties are having
Then
sexual intercourse.
They leave it there.
Madam.
So that is how the court has arrived at a conclusion, and that is the best plea the wife could have taken. But you have fortified her case by filing this judgment. Judgment of a competent court where the court has arrived that you are living
This
together.
judgment was not filed before the High Court. This judgment was not exhibited. This is my case before my lordship.
Okay.
This judgment was not exhibited before the learned court below. Lordship may kindly see
No, so
57.
So if you want to do not pay, that you have to deposit the money.
Hello?
You have to deposit the money. If you do not want to pay the lady, you have to deposit the money because the Rajneesh versus Nya is very clear on this. And earlier Supreme Court decision Chanmunia versus Kushwaha,
Madam.
what they have relied on. Because rather, if the magistrate asks to prove the marriage, then that's a mistake on part of the magistrate. Because Supreme Court has said that it is not job of the magistrate. That is another problem.
He has convicted the present petitioner under section 493.
So that would help the lady in saying that yes, it is a cohabitation. At least.
It is a deceitful, it is a deceit.
Whatever.
Yes.
It is a cohabitation, that part. So Abhijit Misra for the petitioner. Opposite party blank. The learned counsel for the petitioner is hard at length. The petitioner in the petition challenges the judgment dated
9/1/26. 9/1/26, Annex 2, page 41.
912026. passed by the Learned Judge Family Court Kendrapada in criminal proceeding number 269 of 2013. Stop. By the said judgment. The petition filed under section 125 of the CRPC by the opposite party herein, who was the petitioner. Opposite party lady who was the petitioner was allowed. The learned trial court, the learned judge family court को दियो relied on the evidence of as many as 14 PWs appearing for the petitioner. No one was examined on behalf of the petitioner herein, who was the defendant.
Again, नहीं तो PW
अच्छा,
को समान एग्जामिन करते हैं 3 जन.
Again, I have opened the wrong page. कौन लिख ले? नहीं, काटन तो. The learned trial court, the learned judge family court तो काटी लिखन तो. The learned judge family court has relied upon the evidence of the 3 witnesses on behalf of the petitioner, 5 witnesses on behalf of the opposite party who was the petitioner, 4 exhibits marked at the instance of the lady petitioner, and 6 exhibits marked as exhibits by the petitioner who was the defendant. Stop. It is contended by the learned counsel for the petitioner that for consideration and grant of monthly maintenance under section 125 of CRPC, the person seeking maintenance has to be the wife. In this case, the marriage is disputed by the petitioner. And therefore, the opposite party is not entitled for any maintenance. Annexed to the writ application is the judgment of the JMFC, Kendrapada, in GR case number 1149 of 2011, trial number 212 of 2016, wherein the petitioner faced trial under sections 493/420/323/506 IPC. Referring to the said judgment of the learned JNFC, it is submitted that conviction of the petitioner would indicate that the charge of deceitful intercourse, what is it? 493?
Promise of marriage with a deceitful means. That is 493. 493.
493 IPC.
IPC.
The said section is reproduced here.
And 417.
493, 417.
Mal. 417 is cheating.
the section 493 as contained in Indian Penal Code 1860, since repealed and substituted by the perimeteria provision. Section S.81 of the BNSS 2023 is reproduced herein. 493 ta reproduced further. To consider the constitutions made by the elaborate submissions made by the learned counsel for the petitioner, this court takes note of the judgment tendered by the Honorable Apex Court in Rajnesh versus Neha and another colon into bracket 2021 bracket closed 2 SCC 324. INSC टा भी देई पारे किंतु INSC दउछंती. The relevant paragraphs of the SCC print are reproduced here. Para 13 guidelines for headings with 13, 14, 15. Here are 14, 15. Then 32 with heading. Yeah, heading करा है चीज़. Supreme Court judgment रे 32, 33, 34, 35, 36, 37, 38, 39, 40. चालीस तापर 43, 44, then article 141 ta कुछ is then 114, 114, 15, 114 ରୁ 17, 114 ରୁ 17. कहे 25 ରୁ 125, 26, 27, 127, 134. You take instruction whether he will secure. Whether he will secure the decree, then I will issue notice. Otherwise, past orders. Today, after instruction, in view of the authoritative pronouncement by the apex court in Rajneesh versus Sneha, that the amount awarded as maintenance is akin to money decree.
money decree again, it came through.
Supreme Court kହୁchunti bila. Though the learned counsel, though the learned counsel for the petitioner seriously disputes that it cannot be a money decree.
Under
The
chapter,
paragraphs
under the
quoted from
chapter,
the Supreme Court, paragraphs quoted from the judgment of the Rajneesh versus Neha indicate that
se chapter ra to tara execution that pura chapter, it is a complete code, that chapter itself.
file review curative Rupa Ashokura versus Ashokura ସେଠି କରିବାକୁ ପଡିବ
ନାଇଁ Rajneesh versus Neha ର ତ ହବ
indicate that the amount awarded has to be enforced like a money decree, and any challenge that too would necessarily require securing the decree before this court. The revision file is in it.
Revision.
In the revision. Stuff. जोटा आपण गोटे ऊपर लिखचंती जे रिलायंस ऑन द जजमेंट बाय द जेएमएफसी सेतरे पैराग्राफ ता होची page internal page 26 nahi 37 running page 37 paragraph starts. The learned JMFC has concluded on revisiting the totality evidence up to criminal intimidation. Stop. तापरे एटा रहइबो paragraph गुडा आपण simply reproduce करंतु. Yes. The matter shall be listed in the week commencing 27.
Notice आगे कर नहीं.
No. It has to be dismissed. Because after going through this judgment, the woman not lawfully married to him to believe that she is lawfully married to him and to cohabit with him in that belief. So that is rather a telling, but I am not dealing with that. Since it is on record, I am...
That appeal is pending till date. Who knows what will be the result in the appeal?
Correct.
That
it is submitted
judgment
by
may be set aside.
Petitioner.
The judgment may be set aside.
That appeal against the judgment
is pending.
Rendered by the judgment dated 8/12/2016.
Appeal is pending before
who knows what would happen to the judgment. The said submission is correct.
The criminal number 18 of 16 is pending before the additional session judge Kendrapada. That I have exhibited.
The submission is correct that nobody knows what would happen to the appeal. But this court cannot proceed on the presumption that the appeal will be allowed in favor of the appellant before the learned judge, additional district judge, learned additional session judge.
Additional session judge
Kendrapada.
The presumption is also vice versa. Who knows that?
No, I am recording your submission. That is not my. I am recording I am diligently producing your submissions.
Lordship may kindly notice and directed
counsel for the petitioner repeatedly insists for issuance of notice.
Pay something out of the amount.
But without being satisfied prima facie that a case has been made out for revision as rendered by the Honorable Apex Court in Sabima Faruqi, paragraph 2021. Issuance of notice in a matter where maintenance have been awarded by the judgment of the Learned Judge Family Court in a provision under section 125 CRPC would not be in the interest of justice. Stop. He has to secure. He has done enough of it.
Lordship may direct to deposit some amount.
ତାଙ୍କ ସାଲାରୀରୁ ସେ ରେଞ୍ଜର ଅଛନ୍ତି, ତା ସାଲାରୀରୁ ବି କରିହବ।
Salary ନାହିଁ, ରିଟାୟାର୍ଡ କରିଗଲେଣି, pension ରୁ
ସେ ଯାହା ତାଙ୍କର ଥିବ ସେ he has enough of it. And the other aspect is that the Lorette trial court has not gone into that conviction also.
No.
It has also to be noted that though the petitioner has chosen to file before this court the copy of the judgment rendered by the JMFC, the said judgment has not been relied upon by the Lorette trial court in dealing with the petition under petition filed by the lady under section 125 of CRPC. ସେ କେତେ ଟଙ୍କା ମେଣ୍ଟେନାନ୍ସ କରିଛନ୍ତି?
maintenance करते 2,500 ଟଙ୍କା କରିଛନ୍ତି from the date of application.
Too frugal, Mr. Mishra.
ନା ମୁଁ maintenance amount
I mean, he would have lost his job. He would have lost his job.
maintenance amount ଉପରେ ମୁଁ କିଛି କହୁନି, lordship direct
Conviction ପରେ ଆପଣଙ୍କର conviction ବି stay ହେଇନଥିବ।
ଆଜ୍ଞା
Sentence ଟା stay ହେଇଥିବ।
ହଁ suspension of sentence conviction ଆଉ କଣ stay ହଉଛି କି ଆଜ୍ଞା? Conviction is rare cases of conviction.
Leave it there. 2,500 ଟଙ୍କା for the lady is not that much. ସିଏ ହୁଏତ ଆସିଲେ enhancement ପାଇଁ ଆପଣ ତାଙ୍କୁ କହିବେ କଣ ground ରୁ ସେଇଟା ଅଲଗା କଥା।
ତମ ଡାଇରେକ୍ସନ ଟା ଟିକେ ତାହେଲେ ମୁଁ ଆଜ୍ଞା ନେଇଯାଏ instruction କାଳେ ସେ ଯଦି ପଇସା ଯଦି ସିକ୍ୟୁର କରିବେ lordship
I am not disposing of. Please don't. Because I don't want to repeat this exercise again.
Oh.
I am just recording. I am not disposing of.
नहीं, what I humbly pray, my lord, Since
The petitioner seeks and has adjournment to obtain instructions, further instructions from the petitioner.
since the ordering portion reflect that 2,500 from the date of application. Date of application is 36/2010.
Yeah.
So it is around 15 years. 15 years into 12 into 2,500. I am just calculating it. Lordship may direct to deposit so that Lordship will issue notice and stay this.
After you file that affidavit, the allotted counsel for the petitioner shall have the liberty. The petitioner shall file affidavit if so advised, indicating how he will secure the amount directed to be paid, which remains due 36/2010. Just once.
Due from 30/6/2010 date of application.
One 189 months ହଉଛି ନାଇଁ କି?
4.5 ଲକ୍ଷ ଟଙ୍କା। पंद्रह इंटू 12 इंटू 2,500
4,72,000
आज्ञा
the petitioners shall file affidavit indicating whether the amount due for since 36/2010 30.6.2010 till March 2026 for the 189 months rupees 2,500 पूर्ण 189 ଯେତିକି ହେଲା whether କଣ ଲେଖିଲେ whether he can secure shall have the shall if so advise shall file affidavit whether he will secure the amount. Yes, before this court. for issuance of notice. Yes, issuance of notice काटी दियो. So they will not, the affidavit not they be parent. Yes, let us leave it there. Yes. List in the week commencing 27 4. 27 4.
ସେଠି ଏତିକି ଦେଖିଲା ପରେ ସେ ଯଦି କହିବ ଆଜ୍ଞା ସାର୍
ବେଲେ ସେ ଭଲରେ ଅଛନ୍ତି, ଚାକିରି ଅଛି, ପେନସନ ଅଛି, କନଭିକ୍ସନ ହେଲା, କନଭିକ୍ସନ ହେଇକି
ପେନସନ ପାଉଛନ୍ତି
ସବୁ ଚାଲିଯିବା କଥା. ବର୍ତ୍ତମାନ Mr. Mohanty is because he's to satisfy his name he is not active. Otherwise if he writes a letter that so and so ranger, he is well within his capacity after being conviction.
appeal is pending my lord. Who
that will a lighter vein. appeal करे जितिला ପରେ ସେ ପୁରାଟା ପାଇବେ. You also do service law, you know it.
He may withdraw the revision on the next date, the petitioner.
He should. Sufficient material, and you have been very, I mean, rather in a fair approach. I don't know what came to your mind. You have presented that judgment.
Yes.
The judgment has nailed the issue. And he's a master. You should not believe him. He will manipulate in the lawyers also. He uses addresses. He uses names. He uses subnames.
ମୁଗୁତ
I mean, ଆପଣଙ୍କର ଏକ୍ସାକ୍ଟଲି ଆପଣଙ୍କୁ ସେ ପଚାରିବେ ଆପଣଙ୍କର କଣ ଅଛି, ତ ଆପଣ ଉତ୍ତର କଣ ଦେବେ? ୟୁ କ୍ୟାନଟ୍.
ଆମ ପାଖକୁ ଲୋକ ଆଜ୍ଞା ଆସିବେ, 5ଟା ଡକ୍ୟୁମେଣ୍ଟ ଦେଖେଇବେ, 5ଟା କଥା କହିବେ, ଆମେ we have to believe.
Very difficult. In fact, that I was telling you that he will listen to you.
ଅବିଶ୍ୱାସ କରିବୁ ତାହେଲେ ତ ଓକିଲ ଆଜ୍ଞା ବନ୍ଦ ହେଇଯିବ.
ଅବିଶ୍ୱାସ କଥା ନାହିଁ. You cannot advise them. That's the problem.
ସେମାନେ ସବୁ ଜିନିଷ ସାରି ଦେଇକି ଆମ ପାଖକୁ ଆସୁଛନ୍ତି ନା ତଳେ.
ଆପଣ ତାଙ୍କୁ ଭଲ କଥା କହିଲେ ସେ ଶୁଣିବେନି.
ବାସ୍ ତେଣୁ ଫ୍ରମ ଦ ଇନସେପସନ ଯଦି ତାଙ୍କୁ ରାଇଟ୍ ଆଡଭାଇସ କରାଇଥାନ୍ତା ମ୍ୟାଟର ଏତେ ବାଟ ଆସିନଥାନ୍ତା. ଟଙ୍କା 2,500 ଆଜିକା ଡେଟରେ କିଛି ନୁହଁ. ଦିନକୁ 100 ଟଙ୍କା ବି ପଡୁନି. ଦିନକୁ 100 ଟଙ୍କା ବି ପଡୁନି ଏକ୍ସପେନ୍ସେସ୍.
there is no reason ସେ 2,500 ଟଙ୍କା କାହିଁକି କରିଛନ୍ତି କିଛି ଲେଖିନାହାନ୍ତି. ସେଥିପାଇଁ perhaps you said that the affidavit is on record, but I am not agreed by the quantum.
ଆଜ୍ଞା.
Yes, next.
Okay.
Item 9.
May it please your lordship, I am for the petitioner. Pursuant to in obedience to the last court's order, I have filed the complaint affidavit indicating the details of proceedings initiated on the matter. The first one is that the opposite party initially instituted a proceeding under section 125 CRPC, which has been registered as
Sir, Mr. Actually, ଆପଣ ଡେଟ୍ ଅଫ ଯେବେଠୁ ଯୋଉ ଡେଟ୍ ରେ ଯେତିକି ଜଜମେଣ୍ଟ ହେଲା ଆପଣଙ୍କର ଡାଇରେକ୍ସନ କେବେ ହେଲା ଏଇ ଯୋଉ ଜଜମେଣ୍ଟ ଆପଣଙ୍କର ଏଫେକ୍ଟିଭ ଡେଟ୍ କେବେଠୁ ପେମେଣ୍ଟ ପାଇଁ ଡାଇରେକ୍ସନ ହେଲା?
I am submitting my lord.
ଆରେ ସେଟା ସବମିଟ କରନ୍ତୁନି, ସେଇଟା ଆପଣ ବିକଜ that becomes a arithmetical calculation. You should have filed a simple one page, one simple table. ଆପଣ ଗୋଟେ 5 ପେଜର affidavit ଦେଇଛନ୍ତି. I don't require that. For that matter, no court will require that. ଆପଣ ଗୋଟେ operative portion ଟା ପଢନ୍ତୁ, page 17 of your brief.
Yes, madam. Yes, madam.
Kindly read the order.
Petition filed under section 146 BNSS by the petitioner against the OP is allowed on contest. The petitioners are directed to pay ₹4,000 each month to the opposite party towards our maintenance in place of ₹7,000 each as awarded earlier. The reduced maintenance amount shall be payable from the date of this order and shall be paid by the petitioner to the OP on or before 10th of each succeeding month regularly.
So, first order କେବେ ହେଇଥିଲା?
The first order was passed on 4/11/24. And it is available at page
18 ଟା ଦେଖନ୍ତୁ.
Yes, madam.
କୋଉଠି ସେଟା ଆପଣ କହୁଛନ୍ତି available ବୁଝିପାରୁନି କୋଉଠି?
Page 19, my lord. Page 19 is the order, first order. And the operative part of that order is available at page 27.
So ଆପଣଙ୍କ 15/2/24 ରେ ହେଲା ଦେବେ 7,000
ହଁ 4/11/24 ରେ 7,000 ଲେଖା କୋର୍ଟ ଫିକ୍ସ କଲେ ଜଣକୁ।
4/1/24 ରେ ହେଲା
ମାଇଲର
27/1/26 ରେ।
ହଁ 27/1/26 ରେ ରିଡ୍ୟୁସ୍ ହେଲା 4,000।
ହଁ ଆପଣ 15/2/24 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଯେତେ ଟଙ୍କା ଦେଇଛନ୍ତି ଆପଣ then go back to the order number 1
I paid
ଦେଖନ୍ତୁ ଅର୍ଡରଟା।
well, in total we have deposited 94,000 minor before the loan and plan.
It could be 94 or that's not important. ଆପଣ 15/2/24 ରୁ 27 ଆଜି ପର୍ଯ୍ୟନ୍ତ 94,000 ଦେଇଛନ୍ତି।
ହଁ 94,000 ଟଙ୍କା डिपॉजिट।
That is nothing. पंदर 2/24 ରୁ ହେଲା 27/1/26 ନାଇଁ କି?
And the most surprising thing, the opposite party has not yet collected the amount from the court below.
Nothing to be surprised because I think with your experience you know that when you frustrate a order nobody comes to court. My little experience this side is that most of the cases the wives are not responding because it is their personal case. It is they are not fighting for a money decree. A award is made.
No, here
So why they will come?
No, my lord, here
because maybe they are scared of the court. They are scared of the lawyer. I will say about the court because I can't say about the lawyer. They are scared of the court that this process is itself onerous financially.
My lord, here the case is different. The opposite party is the mother of the petitioner. That is the whole faithful case. And the third son is hoisting this case, my lord. Although I have filed petitions to take back my mother to my home, the third son is not permitting. And it is only at his instance the proceedings were culminated.
The lady is unfortunate, sir. The sons are made him a pawn, made her a pawn.
No, my lord.
ସେମାନେ ତାକୁ ଗୋଟି ଚଳେଇକି ଯଦି ଆପଣ କହୁଛନ୍ତି if your version is to be accepted, you are saying that the sons are moving the pawns.
The third son, my lord. It is the petitioners are the first and second son. And it is the third son who is
ଆପଣ ଯୋଉଟା ଡିପୋଜିଟ୍ କରିଛନ୍ତି 94,000 କୋଉ କୋର୍ଟରେ କରିଛନ୍ତି?
family court in execution case number 11 of 2025. Even yesterday I deposited 59,000 man.
Sorry, ଆଉ ଥରେ କହିଲେ 59 ନା 69 ସୁବିଲାନି ଟିକେ
59 madam.
ଆଚ୍ଛା 59
ହଁ 59. And that is the reason I have prayed for stay of the execution, my lord. Because the only thing is that my mother possessed
94,000 ଟା ପୁରା ଏକ୍ଜିକ୍ୟୁଟିଂ କୋର୍ଟରେ ଡିପୋଜିଟ୍ କରିଛନ୍ତି?
already deposited, my lord.
ସେଟା ଲେଖିଛନ୍ତି କି affidavit ରେ?
No, my lord, because the amount
That is the problem, sir. I don't require any elaboration. I simply want 2-3 facts. The learned counsel for the Mr. R.N. Devata for the petitioner, opposite party blank. The ଆପଣ ଆଉ 50,000 ଟଙ୍କା ଡିପୋଜିଟ୍ କରିପାରିବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି?
I will have to take instruction, my lord.
But you are sure that when you are saying that the lady has not come to receive any amount, that is you know that?
No, because I have also, my lord, filed a petition before the Law and Family Judge, so directing the mother to accompany us so that we can take her to our home. Because she is residing with our third brother and who has been exploiting the mother.
No,
So
that
the mother,
you are saying that the money is lying with the executing court.
huh?
So that you are sure you have stated in the affidavit. Your client has stated in the affidavit.
No, my lord. But I'm sure. Yesterday I myself went to the court to find it. And if your lordship directs, I can also deposit some more amount.
By what time you can deposit?
Within 10 days, my lord.
So after you deposit, or because the difficulty is that if it is a conditional order and not compliant with notice cannot be issued. So better you deposit and come back.
Yes, ma'am.
Because there is a method. Why I say that file affidavit, because conditional orders are not compliant. Perhaps the person, whoever may be the person.
No, my lord, I undertake to deposit. Your lordship may kindly pass an order to that effect.
No, I am not passing any order. I'll say that some more amount shall be deposited, 50,000, or I'll direct 50,000.
Let it be, my lord, 30 or 40,000 so that it will be convenient. Because the petitioner number 1 is a retired clerk of a civil court.
ଆପଣ କହୁଛନ୍ତି କେତେ କହୁଛନ୍ତି କେତେ ଆମାଉଣ୍ଟ କହିଲେ 30,000
ହଁ 30,000 ଟଙ୍କା ହେଲେ ହେଇଯିବ।
30,000 ଆଚ୍ଛା ଠିକ ଅଛି କଣ ଲେଖିଲେ appearance lecture the learned counsel Mr. R.N. Devata is heard at some length being present at the virtual court High Court of Orissa at Sambalpur. He refers to the order dated 11/3/2026 that was passed after hearing the learned counsel. Stop. He submits that affidavit dated 23/3/2026 has been filed. Stop. The said the said affidavit is available on record marked as flag B. Para. The learned counsel refers to the affidavit to submit that amount of rupees 94,000 has been deposited in the before the learned judge family court in the execution proceeding. So number ta kete?
11/25.
11/2025. Stop.
Okay.
As per latest instructions obtained. Stop kar likhiye. As per the latest instructions obtained, the said amount still lies with the learned executing court without being received by the opposite party mother. Stop. It is submitted that the opposite party mother stays with another son who is brother of the petitioner. Stop. It is submitted that the petitioner shall file deposit rupees 30,000, further amount of rupees 30,000 within 10 working days.
Within 10 days.
Within 10 working days. The matter shall be listed for fresh admission on kebe hele habo in the week commencing 13/4
Obvious, madam.
the week commencing 13/4/2026. Yes.
Item
So on so you also if you can file that with a memo, the proof of deposit you file it with a memo so that it will be available on record.
Yes, madam. I will deposit in the London before the London trial court, madam.
Wherever the 94,000, as you have said that you have deposited 94,000, I think in the executing court.
In the executing court.
Or in the court in the execution proceeding. Maybe the same court, London Judge Family Court. Yes.
Item 10.
Yes, please.
This is a revision against the award passed against this petitioner by the family judge to pay maintenance of rupees 88,000.
Sir, you were heard on the last occasion on 9th of March.
Yes.
So kindly refer to the said order.
Pardon?
Kindly refer to the order dated 9th of March, sir. क्या कौन सा देखिए ना? Calculation ଦରକାର ନାହିଁ ଯାହା ଅଛି ତ ହେଇଯିବ ହେଲା calculation ଆପଣ ଜଣଙ୍କର strong arithmetic ଥିଲେ କରିପାରିବ. So you want to re-argue the matter or you want to respond to the court's discussions that day, legal issues? ସେ 2,32,000 ଆପଣ ଦେଇଦେବେ?
No, my lord. I don't have the money. I'm only earning 7,000 rupees from my.
Sir, you may not earn anything also.
My lord.
So that's a matter of proof before the court. The learned counsel for the petitioner submits that on being asked
glance to the
whether he will read Samima Faruqi. If I start glancing at papers that amount to non-application of mine.
My lord, no.
So please stop interrupting when I'm dictating the order. The learned counsel for the petitioners was asked to go through the order dated 9/3/2026, where his submissions were noted and the deliberations were also noted involving the legal issues. It is emphatically stated by the learned counsel for the petitioner judgment debtor will not pay any amount.
Don't me, lord. I'm not telling you that.
As he is not earning any amount. Para.
I'm not telling
whether the petitioner is earning any amount or not is a matter of evidence on record. That was to be proved before the learned. That was to be pleaded and proved before the learned judge family court in the proceeding. Prima facie, the learned court, on perusal of the judgment, as has been indicated in the order dated 9/3/2026, the learned judge family court proceeded on the basis of the materials on record that the petitioner is serving in the Danagadi block as clerk earning rupees 30,000 per month. Stop. The said submission and assertion of the wife remain unrebutted. It further remained unrebutted that the amount of rupees 1 lakh agriculture income by the petitioner husband. Stop. In view of the categorical submission of the learned counsel for the petitioner that the petitioner will not pay any amount or secure the amount before this court, this court has to proceed on the basis of said submissions. Stop.
Milord, I never said that I won't pay.
Sir, ଏଇଟା ଆଉ ଥରେ ବଜେଇବେ ତାହେଲେ ଆପଣ ପାସ ଓଭରକୁ ଶୁଣିକି ଆସନ୍ତୁ. ଆପଣ ଏଇଟା ଗୋଟେ ଆଡଭାଣ୍ଟେଜ ଅଛି, ଏଇଟା ଆପଣଙ୍କ ରେକର୍ଡିଂ ହେଇଯାଉଛି. ଆପଣ ଏଠି ୟୁଟ୍ୟୁବରେ ମୋବାଇଲରେ ବଜେଇକି ଦେଖିକି ଆସନ୍ତୁ. So that ଆପଣଙ୍କର ଏଇ ଯୋଉ ଥରେ କହିବେ I am unable to pay, I am not pay, ତାପରେ I am never pay.
I am telling you, I never said that I won't pay.
Sir, whatever you have said is on record. I cannot add or subtract. Same thing with you also. You cannot add or subtract or improve. Is what you want? Dismissal or adjournment or?
Let the matter be adjourned. I will satisfy the honorable.
No, I am fully satisfied. The learned counsel for the petitioner on being asked he says that he will satisfy. The matter cannot be adjourned repeatedly at the instance of the petitioner.
My note, sir.
Sir, note, you read the Samima Faruqi. The learned counsel for the petitioner hands over a note before this court, which was not part of the record in the proceeding before the learned trial court. The scope of revision by the High Court of these orders has been authoritatively dealt with by the Honorable Supreme Court in Samima Faruqi versus Sahid Khan, colon into bracket 2015, bracket close 5 SCC 705. The learned paragraph belligerence in law has some limitations. The counsel, that is the limitation of a court. I can't be belligerent. Here is 20, para 20 and 21. Then you'll understand what is the scope. Para 20 and 21. Learned counsel for the petitioner, kindly read it aloud so that I can hear, because I have handed over you my copy. Sir, ଆପଣ ଯଦି ନିରବ ପଠନ କରିବା କଥା sir ଛାଡି ଦିଅନ୍ତୁ. ଆପଣ ଯଦି ପଢିବେ ତାହେଲେ if you want to discussion on the point, then you read para 20. Kindly read.
Adjourn କରିଦିଅନ୍ତୁ, adjourn.
अरे पढ़िबिନି ଆପଣ ଫେର କହିବେ ଯେ I have done this. My lord may kindly see the notes. Supreme Court कौन कहले whether I will see the notes तल दियन छाड़न. But this is not a law class, sir. आपण निरब पठन करिवे. We are interacting in court of law. You will be silent. दियन. Para 20. देखंतु. In the instant, the High Court has reduced the amount of maintenance of rupees as is manifest. The High Court has not, kindly listen to this, and you will not read. As is manifest, the High Court has become oblivious of the fact that she has to stay on her own. Needless to say that the order of the learned family judge is not manifestly perverse. That's the first point. There is nothing perceptible which would show that the order is sanctuary of errors. In fact, when the order is based on proper appreciation of evidence on record, no revisional court should have interfered with the reason on the basis that it would have arrived at a different or another conclusion.
That is my point, Milo.
Correct.
That is my point.
Exactly.
My point
And
is,
counsel for the
my point is that, Milo,
you cannot do that.
no, Milo. My
You
point
cannot
is,
read that.
without proper appreciation, the order has been passed by the
So
family
that
court.
point is well taken.
Not into the notice of this honorable court.
So from your written statement.
Only bald allegation, no material before the
Kindly
court.
show from the written statement. It is submitted by the learned counsel for the petitioner that the judgment is result of the judgment is erroneous as the the court has not appreciated the evidence in its proper perspective. He is asked to show from his written he is asked to show from the written statement filed by the petitioner and the evidence laid before the learned trial court in terms of the law laid down by the Honorable Apex Court in Samim Supra at paragraph 20. Dekhantu, yes. Written statement dekhantu. Page, sir, para
Nice.
Which page of your brief? Which page of your brief? Revision the page.
No. Page taken. Running page 25, my lord. There I have stated my income is 7,000 rupees.
अरे आपनको written statement टा को पेज रो आरंभ होची कोंतु सर आपनको RPFM टा केते
And then the evidence of opposite party at para 44 million.
आपनको को केस नंबर टा केते ता ठीक अछि त को पेज रे आपनको written statement अछि.
I have not filed the
learned counsel for the petitioner on being asked to refer to the written statement. He submits that he has not filed the written statement before this court. Yes, next.
My point is, her evidence is nowhere brought into record that I answered 30,000 rupees because it is her case that I am a employee of the state.
ଆପଣ ପଢିକି ଆସନ୍ତି ନା ନ ପଢିକି
ମୁଁ
ଆସନ୍ତି?
ଆଜ୍ଞା ପଢିକି ଆସିଛି।
Kindly see the her statement. ଦେଖାନ୍ତୁ ତାଙ୍କର examination in chief ଆପଣଙ୍କ class examination.
Have a glance to para 44 million running page.
ଆରେ ରନିଂ ପେଜ କେମିତି 44 ହବ? ଆପଣଙ୍କର କୋଉଠି ତାଙ୍କର ଅଛି?
Para 11.
ତାଙ୍କର ଏକ୍ସାମିନେସନ ଇନ୍ ଚିଫ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି କୋଉ ପେଜ?
Para 11.
ଗୋଟେ ବ୍ରିଫରେ କୋଉ ପେଜରେ ଆପଣ ରେଫର କରୁଛନ୍ତି ସାର୍? The learned counsel for the
Evidence
says that
number 4, running page 44 of the brief, sir.
the learned counsel for the petitioner is asked to refer to the deposition of the petitioner claiming maintenance. He refers to page 44 of the brief.
She has only stated that
अरे कोडा आज्ञा सेमती भाषण दियंतु नै आज्ञा प्लीज बी स्पेसिफिक इन योर को पेज रे को पैराग्राफ पढुतु ही हैज
44 para 11 milord have a glance.
44 हां
Awesome.
ସେ ଭଲ କରୁଛନ୍ତି ଆଜ୍ଞା ସେ ଆପଣ ପେଜ ପେଜ ପାଉନାହାନ୍ତି ସେ କହୁଛନ୍ତି କାଇଁ ରାଖୁଛନ୍ତି ତାଙ୍କ ଉପରେ ପେଜ 11 ପଢୁନାହାନ୍ତି para 11 ପଢନ୍ତୁ.
I am not to maintain myself.
Examination in chief.
And my father has also maintained me on the other OP serving at Dhanavati block and receiving salary of about more than 30,000 rupees. Besides that, he is also earning about 1 lakh rupees from agricultural source. It is her bold statement. And in my cross-examination, she has stated that no material she has placed before the court to show that I am earning.
Para 11 रो cross examination देखंतु.
Cross examination ने the chief para 11 का तापर
11 रे जो chief कले आरा कोथरे cross करछंती देखंतु.
आज्ञा कहूची para 16 million running page 46.
ठीक अछि आ ठीक से तो para 30 हला ता आपनकर 16 रे होची आपनकर cross examination.
Yes. There she admitted that she has not produced any material before the court to prove that I am earning 30,000 rupees.
Para 11 टा reproduce कर देवे. Page 44 para 11. He refers to the examination chief examination in chief of the petitioner.
So she
para 11. टिके टाइम आपन को सोला पे टाइम तो देवे ना से सुनी पर ना आपन पर्टिकुलर. Para 11 reproduce कर दियो. He submits that. The said examination, the state statement in the examination at para 11. The claimant wife was subjected to cross-examination, which has been recorded at para 16, page 46. Para 16 to go. Yes. Yes, anything else?
Yes, she has stated that I have not filed any relevant material. So that the OP is working in Dhanavati block and earning 30,000 rupees. Similarly, his father only stated that
नहीं आपण आगे petitioners आउ कोन कहिबे petitioner आउ कोन रिलाय करछोती
नहीं for evidence
counsel for the petitioner submits that he doesn't have any other the petitioner doesn't rely any further on any other evidence in chief and cross examination.
PW2 also
आपन डिक्टेशन आपन स्टेनो को देबे मोस्ट डिक्टेशन मोस्ट स्टेनो को देबी आपन ता नै आसी से साइड रो से लिखिबे पढन तो अथरे cross examination to buttress the submission that the judgment is based on incorrect appreciation of evidence. Yes, then he relies on PWT ro koda कहउचंती
PW2 you understand the presentation PW2 the father PW2 further has stated also that I am earning.
The learned counsel relies on the statement of the PW2.
Yes. Running page 48, my lord. Para 4.
The affidavit and evidence of the PW2 annexed to the petition. Paragraph 2.
My lord. 4.
Paragraph 4. Paragraph 4. Cross-examination.
Cross-examination is at para 13 in page 51.
Page 51, para 13. Yes.
And then PW3, my lord.
PW3, chief.
Chief at page running page 54, para 3, my lord.
54. PW3, running page 54, para 3. Cross-examination.
Cross-examination.
Page 57.
Coming.
57.
Cross-examination, my lord.
Page 57.
No, not 57. It's double image. By mistake, twice that very evidence in chief has been filed. So,
Cross-examination ଟା 57 ରେ ବାହାର କରନ୍ତୁ। ନହେଲେ ଆପଣ ଫାଇଲ ଦିଅନ୍ତୁ ମୁଁ କାଢିକି ଦେବି।
running page 63, my lord. Para 12.
କାହାର ଦେଖିଛନ୍ତି?
PW3, my lord. Nilamani Ponda.
57 ରେ କଣ ଅଛି? ପାରା 10 ତାପରେ କଣ ଅଛି?
ମୁଁ କହିଲି 54 ପେଜ ପାରା
57 ପେଜ ରେ ଆପଣ ଆଚ୍ଛା 54 ଅଟକି ରହିଲେ। 57 ପେଜ ରେ କାହିଁ ଯାଉନାହାନ୍ତି?
ନାଇଁ ସେଟା ଡବଲ ହେଇଯାଇଛି।
ଡବଲ ହେଇନି ସେଇଟା ଆପଣଙ୍କର ଆପଣ ଗୋଟେ ଜିନିଷ ଷ୍ଟ୍ରାଟେଜିକାଲି ଭଲ କରିଛନ୍ତି, PW3 କୁ କିଛି ପଚାରି ନାହାନ୍ତି। So now you in cross examination you ask the question that whether your husband earns 30,000. She says again 30,000. What the lauded court will and she says that ଆପଣ ମିଛ କହୁଛନ୍ତି ନା ମୁଁ ସତ କହୁଛି। That is the cross examination.
That is not the question.
So ଆରେ ଆପଣଙ୍କର again you have to go back to ଆପଣ so what the court will infer? The 57 have done the right thing. You have declined to cross examine. Because if you ask a suggestive question that whether you have stated truth regarding 30,000, she again reiterates in cross-examination that he is earning 30,000. So what the court will infer according to you?
My lord, the main thing is when she is telling that I am a clerk in the Danagodi block and that means I am a government servant. So she should have brought certain things before the court that I am an employee and getting salary.
So ସେଇଟା ଆପଣ ଏଠି ତ ଭଲ କହୁଛନ୍ତି, ସେଇ ଜିନିଷଟା ଆପଣ ପଚାରିଲେ ତାଙ୍କୁ କୋଉଠି?
I have not conducted that case, my lord.
କଣ ସେ ଛାଡି ଦିଅନ୍ତୁ ତାହେଲେ?
I have not conducted.
3 ରେ ଦେଖନ୍ତୁ ଠିକ, you should have declined actually. At times by asking too many questions in cross examination, over anxiety to disprove, again she reiterates her submission. ଆପଣ ତ ସିଧା କହିଥାନ୍ତେ ଯେ ଦାନଗଦି ବ୍ଲକରେ ଚାକିରି କରିନି, ସେ କହିଥାନ୍ତେ ତାଙ୍କର ଯାହା ରେସ୍ପଣ୍ଡ କରିଥାନ୍ତେ। ଆପଣ ତାଙ୍କୁ ଆଉ ଥରେ ପଚାରିଲେ ଯେ ଆପଣ ଇନକମ୍ 30,000 ଟଙ୍କା କାହିଁ କାଗଜ ଦେଲେନି, ସେ ସେଠୁ କହିଲେ ଆପଣଙ୍କ ଇନକମ୍ 30,000 ଟଙ୍କା ସବମିଟ୍ କର। So what the court will infer? PW3 ରେ ଆପଣ କହୁଛନ୍ତି 60 ଡିକ୍ଲାଇନ୍ ଯଦି ହେଇଛି ଆଉ ଥରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍
ହେଇଛି ପାରା 63
କୋଉଠୁ ଆରମ୍ଭ ହେଲା କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍ ଦେଖିବେ, କନଫ୍ୟୁଜ ଭୁଲଭାଲ ହେଇଯିବ।
ମିଲନ 63 ରୁ ଆରମ୍ଭ ହେଲା ପାରା 63
ନାଇଁ ଫାଷ୍ଟ ଯୋଉଠି ଲେଖା ହେଇଥିବ କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍
62 रे क्रॉस एग्जामिनेशन लिखा कि नील 63 रे फर्दर क्रॉस एग्जामिनेशन on recall मिला and para 12 she has
Para 12.
yes मिला
Para 12. Yes, any other evidence, Mr.? Anything else, Mr.?
that is the evidence available.
Okay. Having perused the examination in chief of PW1 and the cross-examination done by the petitioner, it has to be held by applying the tests laid down in Samima. That the order of the learned judge, the judgment of the learned family judge is not manifestly perverse. There is nothing perceptible which should show that order is a sanctuary of errors. Stop. It has to be held that the order is based on proper appreciation of evidence on record. Stop. As observed by the Honorable Apex Court, this court, it is paragraph liquid. As observed by the Honorable Apex Court, this court in exercising the revisional jurisdiction should not interfere with the reason on the basis that this court would arrive at a different or another conclusion. Stop. Further, it has to be held that substantial justice has been done and the awarded amount is not a huge fortune that was showered on the wife and it deserved reduction. Regarding the liability of the husband to pay the maintenance, this is 125.
Miller.
Paragraph 16, 17, 18 of the judgment rendered by the Apex Court in Samima Supra are reproduced herein. Following the said principles, it has to be held that 17 टा पढ़िଛନ୍ତି ଓ ଆପଣ ଆଣିନା sorry ଆଚ୍ଛା ମୋ କପି ସେଟା
ଆଣିନି
it should be held that in view of the position in law, it is the obligation of the husband to maintain his wife. Stop. He cannot be permitted to plead that he is unable to maintain the wife due to financial constraints as long as he is capable of earning. In the present case, the case of the petitioner was not before the learned judge family court that he is incapable of earning. Rather, he miserably failed to disprove the specific statement that he was working as a clerk in Dhanagadi block and earning rupees 30,000 per month. He also failed to disprove that his agricultural income is 1 lakh. In Samima, the Honorable Supreme Court, commenting on the High Court reducing the amount of maintenance from rupees 4,000 to 2,000, has held, quote, it only reflects the non-application of mind and we are unable to sustain the said order. Stop. Accordingly, in view of the above discussions, the petitioner has failed to the petition fails. No case is made out for interference in exercising divisional jurisdiction. The petition, in view of the above discussions, no case is made out to interfere. The rest of the matter after recess. I have to rise early, I have some engagement. So any mentions you can mention or you will take a date. You will give a date. Yes, call the list.
Item 11.
So Pushti, password code. He was here. Password code.
12.
So Patra.
My lord,
So Patra has also left.
he was here, but now seeking adjournment.
Okay, okay. No, because at times we are getting stuck in some matters. Okay. Bahar date ke bela
Satish.
Mr. You are Mr. S. Patra.
Yes.
So S. Patra on behalf of Niranjan Prasad Patra. Acha, you S. Patra for the petitioner. You have power. Egata password daki deba hotre na. The matter shall be listed in the week commencing. Kebe kale? 24/26.
That's item 11. My learned senior Mr. Prusti has requested for a short pass of this on this.
Yeah, but I will be have a truncated sitting. I have some engagement. I have to rise around 2:45, 2:50. So that is how it will be posted to another day if he is not coming by that time.
That is what.
Yes. Mr. Das.
But I have challenged the order dated audited page 7 merit.
ଆପଣ ଯୋଉ ଭିଡିଓ ଫଟୋ ସବୁ କରୁଛନ୍ତି ଏଗୁଡାକ କଣ ଆଡମିସିବଲ ହଉଛି?
Because what is paid in this miscase matter, he say he paid that he was not allowed to see it.
ଆରେ ଭିଡିଓ
ମୁଁ
ବୁଝିବାକୁ I am trying to learn from you to understand the subject. ଭିଡିଓ ଫଟୋ କଣ? ଭିଡିଓ ଫଟୋ, what is that video photo?
I have to show that he is easily assessing, allowed to see his daughter. Every now and then he's coming, he's talking with her, and he's making false allegation in the court below that he is not allowed to see his daughter. Therefore, I am your before your lordship.
ये जो वीडियो फोटो टा कितने नंबर एग्जिबिट ट्रायल कोर्ट रे
Activity in sir.
मु कोन ट्रायल कोर्ट
I have challenged.
चाइल्ड नहीं परिबेनी
No,
इंटरेस्टिंग लागे
Marat, I am not exhibiting this. My submission is
that आपण ଯେତେବେଳେ रिविजनल कोर्ट रे आछोंदी एटा रिट पिटिशन टा 227 पावर सो आपण जदी एठी वीडियो फोटो
ना मो কথা শুনুন
আর आपण तो सेंटेंस ही कंप्लीट करिया को दुनांती आ
কোন স্যার
आपण जो एठी वीडियो फोटोटा प्रोड्यूस करछन सेटा ट्रायल कोर्ट रे प्रोड्यूस करथिले कि
just to show your blood I am going to execute
ଭଲ ଆପଣ କବି ମତେ ଦେଖିଲେ ମୁଁ जेटा ଭଲ ଲାଗେ ମୁଁ ଦେଖିବି सेटा कोर्ट मोशन
से କହିଲେନି କି ସାର୍ ମୁଁ କଣ କହୁଛି ମାଲଟ କାମ ଆଇଲି ହିୟର ମି
प्रॉब्लम कोन होची कि we should show some responsibility in your pleading
exactly your order is correct
lecture video photo ମୁଁ सेटा पचे
in that one malord what I want to submit malord I have challenged before the trial court about the admissibility of this miscase without hearing on
admissibility of the miscase no provision ଅଛି ସେଟା CPC ତ
it is
CPC ରେ admissibility କୋଉଟା ଅଛି
section 13 section it is the case is under 13 of the Hindu Marriage Act
correct
he has filed a petition miscase and it is a part of the case
26 ରେ fail करछंती
he has not mentioned anything he said it is a part of the CP
13 ରେ कोन application ଟା admissibility
I have not
13 आपण admissibility challenge करछंती
not this admissibility of this petition under what provision of law he has filed and
सेटा की डिसाइड करियो Admissibility.
I am before Lordship to have a direction to the court.
Definitely, I am also before you. I am before Mr. Das also.
So what I will
So
do,
that is how I am asking you question, this question. Otherwise, I would not have asked you. Admissibility, maintainability has to be decided by the court of the original jurisdiction.
yes.
Yes.
He is not,
Now, he decides against you or in favor you.
he is not deciding, my lord. He is not deciding. He adjourned the case. এটা কোন
Deciding কর তার অর্থ
এটা মানে কোন সাক্ষী এই সে সাক্ষী আনিব মু ক্রস করবি এটা হবে ইন দেব
when there is a mixed question of fact and law, there has been several decisions.
I have
My lord, mixed question of fact and law is not my lord. So when it requires admissive, evaluation of evidence for the court cannot summon witnesses in phases.
it is
ଆପଣ preliminary issue ଯେତେବେଳେ ହେଇଗଲା issue frame ଆପଣ ଲିଖିତ issue ଦେଇଥିଲେ
এটা কোন ইস্যু হবে এটা কোন মিসকেস এই মিসকেস ম্যান হি ইজ টেলিং সামথিং
ଆପଣ miscase ରେ ଜବାବ ଦେଲେ କି
ହଁ ଦେଇଛି
କଣ ଦେଇଥିଲେ
ମୁଁ ডিনাই করতে এলিগেশন
ଆଚ୍ଛା ତାହେଲେ let him decide.
କରିକି ମୁଁ ମାର
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର କୌଣସି କୋର୍ଟର jurisdiction ନାହିଁ lower court को गाइड करिवे other than to act accordance with law.
ভেক্সিয়াস
Vexatious जोटा सेटा आपण जवाब written statement रे देबे
ଦେଇଯିବା
ଆଉ ସେତେ ଯାହା କରିବେ
ଦେଇକିରି ମୁଁ ସବମିଟ କଲି ମାର ସବମିଟେड বেসিং অন মাই রিপ্লাই লর্ডশিপ will pass in order in basis of my written statement.
ଆପଣଙ୍କ written statement ରେ ଯିଏ ଯୋଉ ବିଚାର ହେଉଛି ସେ କରିବେ
in basing on my so
Agree judge ସେଟାକୁ ପାସ୍ କରିବେ order ଯାହା କରିବେ ଆପଣ ଯାହା କରିବେ
I pray some direction to date he not deciding ଗଡଉଛନ୍ତି
ଗଡାଗଡି ଯୋଉଟା ଗଡାଗଡିଟା ଡିସାଇଡ୍ ହେଇଗଲା କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ ରେ ସେ ଗଡି ଯାଇ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ ରେ ଅଟକିଲା କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ କହିଲେ ଯେ ହାଇକୋର୍ଟ ଡିସାଇଡ୍ କରିପାରିନି କୁଆଡେ ଗଡିବ
ନାଇଁ
କରିଛନ୍ତି ଟୁ ବେଞ୍ଚ ଡିସିଜନ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ
ଡେଟ୍ ଦିଅନ୍ତୁ ସାର୍ ସେ କରିବ
ସେଟା କୋଉ ବେଞ୍ଚରେ କୋଉ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚରେ ଗଡିକି ଅଟକିଛି ଆଗରୁ ଗଡୁଥିଲା ହାଇକୋର୍ଟ ଗଡୁଥିଲେ ସମସ୍ତେ ଗଡଉଥିଲେ ବର୍ତ୍ତମାନ ସୁପ୍ରିମକୋର୍ଟ ଏଟା ବନ୍ଦ କରିଦେଲେ ଗଡେଇବା ଗୋଟେ ଆପଣଙ୍କର ଗୋଟେ ଫେମସ ଡିସିଜନ ଆସିଲା ଯେ ଏସିଆନ ରିସର୍ଫେସିଂ ଯେ 6 ମାସ ହେଲେ ସବୁ ଇଣ୍ଟରମିଡିଏଟ ଭେକେଟ ହେଇଯିବ
ଠିକ ଅଛି ସାଉ
ଆରେ କଣ ଠିକ ଅଛି ମୁଁ ତ କହିନି ସାର୍ एशियन रिसर्फेसिंग किसी दिन रहिला परे इट वाज रेफर्ड टू ए कॉन्स्टिट्यूशन बेंच इलाहाबाद हाई कोर्ट बार एसोसिएशन सेठी सुप्रीम कोर्ट हैज पारा 43 रे कहले द रीट कोर्ट्स कैन नॉट डायरेक्ट एनी कोर्ट टू टारगेट एनी मैटर
आई एम नॉट ऑन
सो आपण जो बॉडी बुझुनी सेटा सेठी जा होची आपण सीपीसी रे आपण तो माने बहुत केस करचोंदी स्पेसिफिक प्रोविजन अछि when the plaintiff appears defendant doesn't appear when the defendant appears plaintiff appears defendant appears plaintiff doesn't appear so सेटा आपण पिटिशन देबे जदि से पिटिशन देले से ऑर्डर किछि करले बा करलेनी तापर आपण आसिले हम ठीक अछि
सेटा
आपण आपनकर ऑब्जेक्शन करूछंती तो गोटा आईए फाइल्ड बाय द अदर साइड करेक्ट तार ऑब्जेक्शन ता से ताको विचार करी जा करिवे एक्सपेडिशियस पे जेडी कोंतुनी
एक्सपीरियंस कोरोना दि मो फोन
तापर आ गोटे जजमेंट डिवीजन बेंच जस्टिस ओ कहले दिस द हाई कोर्ट इज एवरी डे डूइंग व्हाट ही शुड नॉट डू बाय डायरेक्टिंग फिक्सिंग टारगेट्स फॉर द ट्रायल कोर्ट्स आपनकर सीपी धरंतु 83 ऑफ 2025 संबलपुर फैमिली जज को पाखरे 20 मसियार 15 मसियार केस पेंडिंग अछि
मु तो डायरेक्ट आई एम नेवर पेड लॉर्डशिप टू
वेरी वेल यू हैव नॉट पेड आई एम नॉट ग्रांटिंग एनी
माय समझे नहीं लेट हिम डिस्पोज कर डिस्पोज न करी बायपास
सेटा या प्रेडिक्ट करि होबनी सी जदी ओटा ऑर्डर करले मु डिस्पोज करिबिनी बोली ताहले आपण आसिले मु संगे संगे देखंतु तापर कोन होची
एरा भी कोन आथि
देखंतु आपण जदी से सेटा ऑर्डर कर देबे जे मु डिस्पोज करिबिनी ताहले आपण चैलेंज करंतु देखिबा कोन होची तापर देखिबे yes तो विड्रॉल ना पाजन
ओटे एडजन करछन डेट देरंतु
आपण जो लेवल रे आर्गुमेंट करछन मु आधा बुझी भी पारुनी
मु
आपण टिके मो लेवल को आसंतु आपण जा कहले मु आधा बुझ आपण कहले जे से
मु टिके तोर गुड बुझी कर मु टिके आसंता
बुझेबे आपण तो गोटे डब्ल्यूएस सी आईएटा कोन कॉपी करनी हंती
कोन कोन सर
आईए 1925 को अपडेट करछन
हां I have given my so called also there.
The Padhubrata, the petitioner wife in the marriage is before this court. ଆପଣ କଣ ଫାଇଲିଂ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ନା କଣ ଚ୍ୟାଲେଞ୍ଜ ଫାଇଲ କରିପାରିବେନି
It is not maintainable at this stage.
ଆରେ ସେଇଟା ସାର୍ ମେଣ୍ଟେନେବଲ ନୋ ଆଟ୍ ଦିସ୍ ସ୍ଟେଜ ସେ କୋର୍ଟରେ କହିବେ ନା ନା
ସେ କୋର୍ଟରେ କହିଛି ସାର୍ ସେ କୋର୍ଟରେ କହିଛି
ସେ ଯାହା କରିବେ ଆଉ କଣ ଶୁଣନ୍ତୁ ଗୋଟେ ପ୍ରୋବ୍ଲେମ ଅଛି ଆପଣ ଆପଣ ଚାହୁଁଛନ୍ତି ଏକ୍ସପେଡିସିୟସ୍ ହିୟରିଂ
ସେଟା dispose ହବ କାହିଁକି?
So whenever you approach the higher court, it actually the approaching a higher court also interdicts the proceeding there. Interdiction ମାନେ ବୁଝୁଛନ୍ତି ତ? So ଆପଣଙ୍କର purpose ଯୋଉଟା ଏଇଟା କାଉଣ୍ଟର ପ୍ରଡକ୍ଟିଭ। ଆପଣ ଯେତେବେଳେ ଗୋଟେ କେସ୍ ଫାଇଲ କରି ହାଇକୋର୍ଟରେ ପେଣ୍ଡିଂ ରହୁଛି ରହିବେ, nobody knows. Then why the judge will venture to decide?
Exactly, whatever lordship any manner.
ଆପଣ ଠିକ ଅଛି ଯେ ଆପଣ ଯୋଉ ଆପଣ ନିଜେ disposal ଦରକାର। ଆପଣ ବର୍ତ୍ତମାନ ଅବଜେକ୍ସନ ଟାକୁ କହୁଛନ୍ତି ଯେ it is not maintainable. Maintainable High Court cannot decide.
No, there I am telling you. There I am telling
fair enough. You can always. Maintainability ଥାଉ ବା ନଥାଉ ଆଗ ଫାଷ୍ଟ ଲାଇନ ସେଟା ଲେଖା ହୁଏ। That it is not maintainable. Non-gender, misgender, maintainability are the first grounds. Whether substantiated or not, it has to be written. Default clause type ର। Even read ରେ ବି ଲେଖା ହଉଛି ଯଦିଓ read ରେ strictly ଇଏ ନାହିଁ। read ରେ କାଉଣ୍ଟର ଲେଖା ହଉନି ସେଇଟା ଆପଣ ଏଠି କହିଲେ ଏଠି କଣ ହବ? Mr. The learned counsel for the Mr. Ashwini Kumar Das for the petitioner. The learned counsel for the petitioner is had at some length. The petitioner wife in the marriage is before this court. Has filed the present writ application with the following prayer. Perusal of the prayer indicates that the petitioner prays before this court for rejection of the IA number 19 of 2025 arising out of CP number 83 of 2025 pending before the learned judge family court Hon'Ble. The learned counsel was asked under which provision such prayer can be entertained. That is, this court in exercising writ jurisdiction, purportedly under Article 227 of the Constitution of India, can direct dismissal of a IA pending adjudication before the court of jurisdiction. Stop. The learned counsel has 6 and has adjournment. List in the week commencing 27/4/2026. Yes, next.
14.
Mr. Somnath Misra for the petitioner. Yes, please.
May I please, Lord, sirs. Let the petitioner school, the English medium school, my lords, in remote area of Varipada, and it has at no point of time more than 9 employees. Lord, there was an inspection by the inspector annexure 1. Though it was clarified to them that some teachers are coming to the school and I'm taking classes and all that to get an experience certificate so that they can get engagement in different schools, my lords, for that purpose only. But however, he has mentioned 11 employees. Your lordship will find that annexure 1, page 11.
Yes.
11 employees. But since that was the case that at no point of time more than 10 employees or 10 employees were there, the petitioner did not pay the ESI contribution. My lords, so matter went like this. Then suddenly in 2024, annexure 2 was received by the petitioner. Annexure 2 is a C19 notice to the petitioner saying that these are the due amount you have to pay. Then by the Annex 3, my lords, I wrote to the corporation that I have not received any letter, any notice. I am not in a position to know. Please give me all the details. Your lordship will find in Annex 3, last but one. I would therefore request you to supply me detailed papers. My lords got it?
Yes, please. I am there.
In connection with payment of contribution under section 25C and all that. Moreover, to inform that none of the staff willing to pay under this. This is not relevant because then, my lords, that he was not supplied with any document. So he could not know about how this demand came. Then, my lords, Annexure 4, without replying this, Annexure 4 is recovery, notice, demand notice was issued by the recovery officer that this much is due, you have to pay. Annexure 4. Then again, Annexure 5, I wrote to the recovery officer that I have not received any letter. Please supply me. That was not given. Those are on in 2024. Then, my lords, in the year 2026, my lord, on 27/2/26, my lords. This is an ESI authority from the local Baripada office. He came and said that you have not paid the dues, so you have to pay. And, my lords, he has mentioned there that your lordship will find in Annexure 6.
Yes.
A request for 1 month time. So
Yes.
this was on 27 of February 2026. Then immediately, my lords, as per Annexure 7, on 23/3/26, the petitioner applied for this 45-pay order before the authority. And on the very same day, by Annexure 8, that was supplied to the petitioner.
Yes.
Then Annexure 8, Annexure 9 is the impugn order, that is 45-pay order, my lords. Though it is the date is given 5/7/2023, but I received it in this 23rd of March 2026. That is how I am before your lordship. And, my lords, your lordship will find from Annexure 9 that though notice...
But that Annexure 1 remains unchallenged. Inspection remains unchallenged.
Not challenged.
Never any proceeding.
No proceeding.
There is no provision also. Is there any provision, statutory provision to challenge Annexure 1, Section 11?
Statutory provision, but I can make a grievance before the authority. But my case is that since he has not passed any 45-pay order, not given any opportunity of hearing to me, I could not place all these facts before the authority. So this
inspection report was with you?
Yes, inspection report was with me. But my case is that I told the inspector also that we are having, this is the arrangement, though there are 11 employees on that particular day, but 2 employees or 3 employees, they were giving on honorary, they were teaching the students in order to get a certificate from the school to get a good job in any other school, my lord. That is the thing, my lords. And those things could have been canvassed before the authority if the 45-pay, before 45-pay order is passed, opportunity of hearing would have been given. Now, my lords, Annexure 9 is impugned. Your lordship will find like that previous case, though notice has been issued, but conspicuously there is no mention as to whether the petitioner has received the letters, my lords. Your lordship will find paragraph 2.
Yes.
In the said so-called notice, the employer was given an opportunity to represent his case in person or through an authorized representative on 10/4/2023 with necessary document to explain the case, but none attended.
So according to you, what best can be done now? Because 11 remains, Annexure 1 remains intact.
No, even if
After
11 act is applicable, then I will pay the ESI contribution as per my strength, my lords. I am prepared to do that also. The school is also willing to pay, but not for 11, for 4, 5, 6, at any time, they roll on, sir, they will pay. Now, this authority has not passed the 45-pay order giving an opportunity of hearing. Let them give an opportunity. I'll produce before the authority all the records. The lordship may fix a date. I'll go there and matter can be solved.
Mr. Ray?
My lord, as per the inspection report under Annexure 1, the inspector found 11 persons, which was authenticated by the principal by putting his seal and signature. Next question, my friend is submitting about passing of the order without giving any notice.
That 11 is statutory.
10 is statutory, my lord.
I'm sorry, not 11. Annexure 1 is statutory.
Yes.
Annexure 1.
Yes.
That is section, that inspection, kindly refer to that in the statute, ESI. This is ESI.
My lord?
This is Employee State Insurance.
My lord, my lord.
Okay. Inspection, that report is which provision?
Provision under section 44 and 45.
45.
And this report is not inspection, this is for survey. The inspector visited premises of different factories and establishment to see whether.
But I mean, that report itself doesn't refer to any provision.
No, madam.
But it is in a format. It appears that it will be something statutory.
Format
Most likely there is no scheduler annexure.
No. This is my lord initial step by the corporation. The inspector will come and visit the establishment, inspect the establishment and report to be given to the authority. Then authority is to pass an order or letter to the institution that you are covered under the BSI Act. So start complying. That has not been done. Here, my lord,
that is your categorical submission. Mr. Ray was listening with rapt attention, actually.
Yes.
So what best can be done, Mr. Ray?
I have to take instruction whether the matter can be remanded.
Remanded which, actually I was discussing which stage. I think it has to go to the stage of you asking them respond to the report.
Yes.
Because in your interest, suppose GSI wants to cover this particular institution.
My lord.
Ultimately, as you very candidly said, that this order in 45A, they say notices were issued, so and so. Sufficiency is not mentioned. No, never in the order. So that ultimately results in a situation where the order is unable to, the order doesn't withstand judicial scrutiny.
Yes.
Like our training or any quasi-judicial authority, he always records that notices were issued on such and such date, served on such and such date. Fixing a date of appearance, all these things, but somehow they don't denote that appearance. They do not actually, they say that on posted to of compo-date, say today, posted to 31/3/2026, none appears. But nothing about the sufficiency. So that is one part. That is the last part, 45A. But at the first instance, when you started this proceeding,
my lord,
you have to obtain, of course, you will obtain instruction. I am not presuming that. But you have to explain them that they have to show to the council at least to appraise the court that yes, they proceeded after Annexure 1. They proceeded further in asking that 44 employer to furnish returns.
Annexure 1, coverage notice must have been issued, informing the petitioner about fact of coverage and for compliances.
Yes.
Thereafter,
because 16 says, paragraph 16 of the report says, the institution is in an implemented area.
Yes, madam.
Beyond that, nothing is written. That coverage notice, you are covered and so that. So maybe they would have covered by getting that opportunity. The 9 would have been covered. 9 employees, as he says. Upon minimum kete?
10.
10. So by say the 9 rakhitive. Maybe. Could be. But anyway, that is academic aspect they can very well. The statute they are exempted.
This is my lord, a survey report. After receipt of survey report, it was scrutinized.
You obtain instruction. I am issuing notice on that.
My lord, madam.
The petitioner is this is a society.
The school, sir.
Proprietary farm or how to narrate.
Educational institution.
Correct, but the legal entity is a body corporate
establishment.
The petitioner is running an English medium school at Baripada is before this court. Challenging the order dated 5.07.2023.
ତଳେ ଗୋଟେ 10 ମସିହା ବି ପଡିଛି ମାନେ 10 ମାସ ସେ ବୋଧେ
କଣ ସେଟା ହେଇଛି
5/7
ଇନଫ୍ୟାକ୍ଟ ଡିକ୍ଟେସନ ରେ ସେଥିପାଇଁ ମୁଁ ଅଟକିଲି
ଆଜ୍ଞା 5/7/10 କରିଦେବେ ଆଉ ସେ 10 ଗୋଟେ ପଡିଛି
5.7/2023
Anyway,
wherein order under section 45-capital A of the ESA Act 1948 has been passed. The Learned Counsel refers to the said order and submits that issuance of the notices is recorded by the Learned Authority. However, regarding sufficiency of notice or otherwise has not been recorded. Stop. It is submitted that the petitioner institution through its representative was never never heard in the said proceeding, nor had any occasion to appear and
apprise
the facts before the authorities. Stop. The petitioner institution was provided with copy of the inspection report of the opposite party corporation dated 11.02.2016, copy of which has been annexed to the writ application at marked as Annexure 1. Stop. It is submitted that after the said inspection report, there is no recorded proceeding wherein the petitioner has been given an opportunity to explain the facts to the authority regarding applicability of the ESA Act and to what extent the petitioner is liable. Stop. Issue notice along with this order. Stop. Mr. Amarendra Prasad Ray, Learned Standing Counsel, who usually appears for the opposite party authorities, being present in the court, shall accept notice on behalf of the opposite parties. Stop. Adequate number of extra copies shall be served on Mr. Ray during course of the day. Stop. Para. The Learned Standing Counsel shall file his wakalatnama within 10 within 10 working days. Upon filing of the wakalatnama, the name of Mr. Ray and Learned Associates shall be reflected in the cause list as well as the case brief. Stop. The Learned Standing Counsel shall also obtain instruction in response to the submissions made by the Learned Counsel for the petitioner.
Right.
IRA कौन prayer ଅଛି?
IRA sir annexure 9 be stayed or no coercive action.
Garnish order है नहीं.
No, garnish order is hey. See, inspector ଆସିଥିଲେ 3 days back. That was my instruction.
IA number 5783 of 2026. The IA has been filed challenging the order under section 45-capital A of the ESA Act, raising a demand of rupees 64 lakhs.
No, 6 lakhs.
अच्छा 6 lakhs rupees. को जा रहे लिखा है
Sir,
3,00473.
एटा 3 lakhs पूरा करचंती.
My lord, Annexure
4 रे
is the recovery notice. It is 4,21,115.
जो prayer लिखी connection थी. जो issue notice है ता पूर्व लिखियो the petitioner challenges the recovery notice dated 26/3/2024 as well as the order dated 5/7/2024. ହେଲା तापर issue notice है तापर लिखियो the petitioner prays for interim stay of the order dated 5.7/10/2026.
नहीं सर 2-3.
Sorry 2-3 नहीं सेटा टाइप है हमर कर दैछन. They have typed it 2-6. Digital have this certain limitations. से थरे से जहाँ टाइप करछंती मु ताको देखि डिक्टेशन दे दोछि. 57 you are right, it is 2023.
आज्ञा मते मिडिल
actually मु 26 कहले आपण 22 कहले so I was corrected but then again 5/7/2023.
हां 20 हमको सप्लाई करले 23/3/26 रे बाय annexure 8.
stop कौन लिखले interim stay of operation of them तापरे the Learned Counsel reiterates for the petitioner reiterates his submission and praise for Katyal. Submissions as noted above and praise for interim stay of so and so, so and so. The issue notice as above. The Learned Standing Counsel shall accept notice along with the writ application. Adequate number of extra copies shall be served during course of the day. Stop. The Learned Standing Counsel shall obtain instruction. Stop. In the interim, it is directed that no further action shall be taken pursuant to the order dated 5/7/2023
and
26/3/2024 and order dated 26/3/2024. It have into bracket annexer 4
yes
till the next date of hearing.
Aye.
केबे मिस्टर केबे आसले हबो 10 सप्ताह लागिबो 3 सप्ताह वी कमेंसिंग 27 ना 5 4-5 वी कमेंसिंग 4-5 2026. So rest of the matters will be repeated. I have to
I may be present matters prayer or Passover or Lordship.
No, I have to rise. I have sought for an appointment, so I have to leave.
One let it come next week.
এটা কেমতে adjust করি হবে? I mean,
Small matter.
give him opportunity of hearing. He is under a lot of stress. ସେ କଣ କହୁଛନ୍ତି ଶୁଣିବା କଥା ଏବେ ଏଟା କେମିତି ଆଣି କରିବେ ସବୁ ଗୁଡାକ କଣ କରିବେ ରିପିଟ୍ କରିଦେବେ ନା ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରିବେ ଆପଣ ଫ୍ରେଶ କେତେଟା ରହିଲା ଫ୍ରେଶ ସରିଗଲା ପାସଓଭର କେତେଟା ରହିଲା ଫ୍ରେଶ ଗୋଟିଏ ପାସଓଭର ଫ୍ରେଶ ରହିଲା ଅର୍ଡର୍ସ ଆପଣଙ୍କର ରହିଲା 10 ରୁ 15 ରୁ 21 15 ରୁ 21 କଣ ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରିଦେବେ ସେ adjust କରିଦେବେ କହୁଛନ୍ତି
let's I may be pardon my lords. There are holidays matter may
itself urgent today it will be difficult.
Sir, online copy ଆପଣ
Yes, that I mean that is the saving grace.
ସେତିକି ହେଇଯିବ
Just one second. Your senior is saying. The urgent certified copy as per rules, the parties shall have the liberty to act upon the copy of the order obtained from the official website of this court. Yes.
Can it be done today, my lords? If it
No,
was
I mean the agenda is that. There is a definite agenda for completing it.
sir 4 दिन छुट्टी पड़ जाए तो नल कहि न
हाँ सेटा आपण 30 से लगे देबे देखि ताकू लिस्ट पैक देबे No, I understand.
Sir.
I understand.
I mean, pardon matter. Interim order being
There is some personal difficulty in my part actually. Then there is a
nothing will happen to this case, my lord.
My lord, I 21.
Yes.
Urgent 7th of April. From 18th, it was urgent till today.
My lord, in item 21, the last occasion.
ते आपण जोटा डेट चाहूचोनी सजेस्ट करो.
Yes, yes.
Sir, 7th of April.
7th of April is date of the trial court at first instance. My lord, the case will be listed with the 21 item on April 20 onwards and the my lord, what happens in this case?
No, ଆପଣଙ୍କର actually ଶୁଣନ୍ତୁ once I stop taking up the cost list, let us not take up an individual matter. That is not in good taste.
Yes, yes.
It should be, I mean, apparently it should be uniform. Please appreciate that. So then why not Mr. Pusti's matter I should take up when he has already passed over matter?
No, I am.
So ଆପଣଙ୍କର କେବେ ଆଣିଲେ ହବ sorry
7th of April.
Sir, that is the trial court date. And this date is posted for evidence from the side of the respondent wife.
थोड़े लिस्ट हे गले आपण देखि देबे भी
Last occasion, I am trying to the case are pending before the Hon'Ble High Court. Please give me at least 15 days time so for the proposal. No.
सेटा हम पे. We are breathing upon their neck.
2 days.
कहीं अर्जुन होची कहीं टेक अप होनी.
2 days sir dele. Again 2 days.
We are having that I mean, also the Honorable Supreme Court.
Again mentioning this case before this Honorable Court.
After we rise, we do those things.
Sir, may I submit, it will be listed 14th and the case will be final disposal within April last. So that it will be convenient for the trial court to lead evidence from the side of the respondent. This matter, which is...
But I will dispose of.
No, the present writ petition.
अब आपन से let us not join this. अरे सात बार तल 6 तारीख नहीं आसुन. 6 तारीख आने देखिबा.
Sir, I will be out of station 7 तारीख दिन.
अरे ठीक है 7 तारीख आसुन. लेकिन आनंतु अपन से दिन भी से प्रयास करि परिबे सर.
Yes.
You are not missing that opportunity.
Much obvious.